This is a hearing outside the jury's presence in a matter of State of New Hampshire versus Vladimir Zhukovsky. I understand defense counsel has a motion to make.
We do,
this
Your
morning.
Honor.
Go ahead.
The evidence having closed, at this time, the defense would respectfully move the court to dismiss or alternatively enter or direct a verdict of not guilty as to all counts. Grounds being that the evidence now all being in, when viewed in the light most favorable to the state with reasonable inferences to be drawn, it is insufficient for any rational trier of fact to conclude that guilt has been proven beyond a reasonable doubt. Without going into too much time about it, since this is similar to the argument we made at the close of the state's case, but things are a little bit different. As far as the question of causation, I would submit that the evidence is insufficient to allow a rational trier of fact to conclude that any conduct on the part of Mr. Zhukovsky is the predominating cause of the collision in this case. The eyewitness testimony is all very inconsistent internally and with each other. It is inconsistent with the physical evidence. The physical evidence, as interpreted by an expert witness whose testimony was essentially uncontroverted, indicates that the collision did not take place as represented by the state. It did not happen as a result of the truck crossing over into the oncoming lane. That the collision in fact took place directly above the center line, and that, again, in the light most favorable to the state, that the primary predominating cause was the fact of the lead motorcycle being out of position and out of control while its operator was, as a matter of law, impaired by alcohol. Would further argue that as to recklessness and as to negligence, that the evidence now before the court is insufficient to establish criminal recklessness or criminal negligence, and again rely on Shepard, on State v. Shepard. We are now in a case that looks very much like Shepard, a very quick and inexplicable, other than by the only evidence that's been presented, which is Mr. Zhukovsky's statement that he was reaching for a drink and took his eyes off the road for a very brief period. Unlike Shepard, in that case, of course, the driver went all the way into the oncoming lane and hit motorcycles that weren't anywhere near the center line. Here we have an impact on the center line, as I've said before, that was as much, if not more, the responsibility of the lead motorcycle operator. So for those grounds, we would ask the court to direct a verdict of not guilty as to all charges.
Okay, who's handling this for the state? And before we go on, at least at this point, we still need mass on anyone who's not speaking, as such as Attorney McCormick or me. Yeah, I didn't make an issue of mass when we had hearings outside the jury's presence, and there were only 6 or 8 people in the gallery, but we've got a fuller gallery today, so hence the reason from asking. So, Attorney McCormick, you may proceed.
Thank you, Your Honor. Obviously, the state has shown a tremendous number of witnesses and put up substantial evidence to show the driving behavior pre-crash, and that's from Gorham really all the way to the crash scene. So, in the light most favorable of the state and all reasonable inferences therefrom, the state has shown something very different than State v. Shepard, where you had a momentary inexplicable deep weaving into the other lane and crossing the line. Here we have sustained and repeated conduct from Gorham to the crash site, and Your Honor, we've heard that from numerous direct witnesses that observed the defendant's driving, and coupled with the defendant's admission that in terms of at the scene and site of the crash. But pre-crash, this is a very different situation than State v. Shepard, where you had one fleeting crossing the line. Here, you had it again repeated from Gorham on. Just the fact that he has this kind of commercial vehicle that he's driving. This maybe doesn't need a CDL to drive that, but it's a large vehicle. He's driving commercially. He has a CDL. He's aware of the risks that he poses to the public with that particular vehicle. He's all over the road. Pre-crash, we've had direct evidence again of this, Your Honor. And at this point, in the light most favorable to the state, and all reasonable inferences therefrom, a reasonable jury can certainly find that the defendant's conduct was both negligent and reckless.
All right, construing the evidence in the light most favorable to the state and all reasonable inferences therefrom, I find that the state has presented sufficient evidence from which the jury could find beyond a reasonable doubt that the state's proven each of the elements of each of the 15 alleged offenses, and specifically that the jury could find beyond a reasonable doubt that the state has proven beyond a reasonable doubt that the defendant recklessly caused the deaths of the individuals named in the indictment, negligently caused the deaths of the 7 individuals named in the indictments, and committed the crime of reckless conduct. Accordingly, the defendant's motion to dismiss at the close of the evidence is denied.